Welcome to Case of the Week, brought to you by the Business Squad's legal eagle, Ben VanGelderen of Benjamin VanGelderen PLC. And this week, we're going to be talking about Hodge versus U.S. Security Associates. And also defendants in this case are Lara and the Unemployment Commission. So there's going to be a lot of information about how you appeal an executive agency decision. And that's going to be kind of one of the focuses today. And then the other focus is really going to be the importance of black and white facts, and you'll see why in a little bit. So this started with Hodge, who was a security agent with U.S. Security, and she was assigned to work at Detroit Metropolitan Airport. One day, a passenger came up to her and asked to help find her departure information. So Hodge went over to the airport terminal and logged in, looked up the departure information, and helped the passenger, assumingly helped the passenger find the way to the gate she needed to get to. Well, it turns out that if you're not authorized to access departure or arrival information, you can't do it. And U.S. Security Associates is very clear that their security people are not supposed to be messing with the airport computers. So Hodge was fired, just like that. And then when she went and applied for unemployment benefits, the unemployment agency said, no, you were fired for misconduct. When you're fired for misconduct in Michigan, you're not entitled to unemployment benefits. So that's kind of the backstory, and then what happened is there was this whole long process that eventually got to the Supreme Court case we're talking about today. So that's kind of what I'm going to go through right now. So the first thing that happens, Hodge gets fired and applies for unemployment benefits, right? She fills out the application. Then the unemployment agency reviews the application and denies benefits. Presumably they gave a letter that said, we are denying your benefits because we find you were fired for misconduct. So then Hodge appeals that decision, and the first step is a hearing within the agency by an administrative law judge. And that hearing is basically just like a trial that you'd see anyplace else. So at that hearing, the judge pulled out 5 facts, and these facts were not disputed throughout the entire process. So these 5 facts I'm about to rattle off are going to be the facts of the whole thing. So the first thing is that the U.S. Security Agency, they had a policy that said agents can't access computers when they're not authorized to do so. Second thing is Hodge knew about that policy. The third fact, she violated that policy in the past. The fourth fact, nobody had ever given her any approval to access the computers and violate the policy under any circumstances. And then finally, when she looked up that passenger's departure information before she was fired, she was in violation of the policy. So the administrative law judge took those 5 facts and said, you know what? It's black and white. Employer had a policy, employee violated it. That's misconduct, no benefits. So then Hodge turns around and appeals that judge's decision to the Michigan Compensation Appellate Commission, which then looked at those 5 facts and said, you know what? The judge said it's misconduct, it's a violation of a policy. We're going to uphold the administrative law judge's decision, and we're going to deny benefits. So all this was happening in the executive branch of government, right? Remember the 3 branches, Schoolhouse Rock, right? So all of these were happening in the agency, the executive agency. And then, because Hodge wasn't happy with what the agency did, she shifted it over to the judicial branch, and she filed a complaint in the Wayne County Circuit Court. And what the Circuit Court judge did is they looked at what was happening, and he said, look, this wasn't misconduct, right? Hodge was just trying to help a passenger. She brought up her departure information. How could this be misconduct? She gets benefits. So the judge said Hodge gets benefits. That's the Circuit Court judge, right? So then, of course, the defendant appeals, that would be the security agency, and Lara appeals to the Michigan Court of Appeals. And the Court of Appeals said, yep, we agree with the Circuit Court judge. Not only that, but actually Hodge was providing a benefit to security associates because she was helping them look good to their customers, helping out with passengers. Like, there's no way this is misconduct. Hodge gets benefits. So then it gets appealed one more time to the case that we're going to talk about today, or we've been talking about for basically the entire amount of time I've had allotted just for the background. But the Michigan Supreme Court came out with a decision. They didn't have oral arguments. They were unanimous on the decision, and it was really only about 2 pages double-spaced long. And they said, Hodge doesn't get benefits. And this is why. The court's job when you have an executive decision that's being reviewed by a judicial branch, right? And this is laid out in the Michigan Constitution, and there's similar. It's a similar process in every state and also in the U.S. On the federal level. And the courts, the judicial branch's job is not to retry cases that were heard before an administrative law judge, right? So they're not examining the evidence to try and figure out whether or not Hodge was guilty of misconduct or not. Their job is just to look at the ALJ's decision and apply the appropriate standard of review, which is basically, did the administrative law judge F up royally, or did they make a reasonable decision? And in this case, when you go back to those 5 facts that I mentioned, the judge made a judgment call, right, and said this was misconduct because she violated a policy. And so the Supreme Court said it's very clear in our Constitution that we do not overturn those decisions if it's a well-reasoned decision that's based on facts and based on good law. So poor Hodge is now out of security benefits because of what the ALJ decided at the very beginning of this entire process. And these are the 2 things that I think we can take away from this. The first thing is that these agencies, these executive agencies, LARA, Licensing, Corporations Bureau, whoever, they have a lot of deference from the courts. So when they make a decision, chances are the courts are going to stand behind that decision. So it's very important, and of course I'm going to say you need to get a lawyer involved right away, but this is why your first response to that agency is so important, because the administrative law judge is going to make a decision based on the first things that you say, based on that first level of trial, based on the first facts you present. And that decision by the administrative law judge is going to be very, very hard to overturn. And if you're going to overturn it, you really do have to find, this was a clear F-up on their part, right? Or they blatantly misread the law. And of course, sometimes there are unique issues of law that really haven't been decided, and then the courts will take a little bit more of a different approach. But if it's just looking at the facts, and just looking at the decision, you really have to make sure that you know what you're doing when you go before these executive agencies, because if you make a mistake and you lose at the trial, you're probably never going to be able to win it. So that's the first thing. And the second thing goes back to sort of those 5 facts that I mentioned. And I would venture to guess that the reason those 5 facts were not disputed by Hodge's attorneys is because U.S. Security did a very good job of documenting every single time that Hodge violated the policy and saying there was a meeting, we told her she shouldn't be doing this, and she knew she shouldn't be doing this, and she signed, maybe she even signed acknowledgments of a warning or something like that. And so there was no question, there was no gray, no disputing those black and white facts, and because of those facts were in place, U.S. Security Agency just rode those facts all the way to the Supreme Court and won. So tying this in a little bit to what the business squad's doing generally, this month, in the month of May, we're talking about businesses that are going into the home, right? Residential businesses. And I think this is really important for residential businesses because anytime you're going into somebody's home, there's usually not any other witnesses around, and usually these types of businesses don't put things in writing because they're more informal, right? Just going to come to your house, do a little bit of handiwork, or clean a little bit, and then you're going to pay me cash and I'm going to leave, right? And the thing that occurs to me about this is how important it is to get the really important facts in black and white. And the example that comes to mind is the general contractor, right? Who comes in, builds a new deck, the deck's finished, and the customer says, well, whoa, wait a second, that's not what I thought I was getting. I thought it was going to be this color, or I thought this is what size it was going to be. And the contractor says, well, no, that's standard. My contract says built as, standard in the industry, right? And so there's all this kind of back and forth. And at the end of the day, nobody wins because it's probably going to have to go to court to have it be decided. And then the judge is just going to have to look at the decisions. So if you're a business owner and you want to protect yourself, you don't necessarily, you don't want to worry about winning in court. You want to keep it so black and white that they can't even take you to court. And the way to do that is to make it black and white, right? If you're a contractor, you're going to be building something, put pictures of the sample if you can, right? Map out the entire deck, exactly what it's going to be, list all the specifications, have the customer sign it, and then the customer can't come back later and say, well, I didn't know the deck was going to be like that, because then you can say, oh, yes, you did. I got your signature right here. Black and white, no question, set in stone. So, hope you learned something this week about the agency review process. If you stuck with me this long, thank you. Hopefully, I will not have to spend so much time on the procedural background of cases in the future, but I did think it was important, since so many business owners have to deal with these agencies, to give you a little bit of a taste as to how they operate. So that being said, I will see you on Thursday at 5 for the Business Squad's happy hour, and then I will see you next Tuesday for my case of the week.